welcome to this week's Weekly Rewind episode. My name is Nilufer and I'm happy to bring you a new episode in our series of Weekly Rewind. This week, the top news is from Kerala, where a bishop was let off in a rape case. For this news and much more, please keep watching this episode. While hearing a case which led the nation to one of the most controversial outbreaks and had lifted the veil to show the alleged atrocities and harassment behind the four walls of the church, Gopakumar, additional judge, has held what seems to be a disturbing case of sexual violence by a bishop intoxicated with power, authority and position was nothing but a faction feud in the church, and the victim was a mere scapegoat in the hands of the priests. The Kerala court has acquitted the former Bishop Mulakkal in the nun rape case, wherein it was alleged that the nun was raped 13 times. Read a more comprehensive report on this very interesting judgment on the SCC online blog. In a detailed judgment, the bench of Justice Chandrachud and Justice Bopanna have upheld the constitutional validity for the reservation of OBC candidates in the All India quota seats for the PG and UG medical and dental courses, and noticed that while an open competitive exam may ensure formal equality where everyone has an equal opportunity to participate, however, widespread inequalities in the availability of and access to educational facilities will result in the deprivation of certain classes of people who would be unable to effectively compete under such a system. On the question whether after graduation an individual is entitled to reservation on the ground that they belong to a class that suffers from social and educational backwardness, the court said that it cannot be said that the impact of backwardness simply disappears because the candidate has a graduate qualification. It was therefore held that there is no prohibition in introducing reservation for socially and educationally backward classes in the PG courses. The bench of Justice Hemant Gupta and Justice V. Ramasubramanian have upheld the NCLAT's order of winding up of the Devas Multimedia Private Limited and observed that allowing Devas and its shareholders to reap the benefits of their fraudulent action may send a wrong message that by adopting fraudulent means and by bringing into India an investment of just 579 crores, 133 investors can hope to get tens and thousands of crores even after siphoning of 488 crores. The winding up of the company was initiated on the ground that the agreement between Devas, a joint venture between ISRO's commercial arm Antrix and USA's Forge Advisors, was a result of fraudulent and criminal conspiracy between the persons in management of the affairs of the company and the officials of Antrix in the Government of India to award a lease of scarce and valuable S-band spectrum without obtaining necessary approvals and without following the applicable norms and procedures. The Supreme Court in such facts and circumstances observed that if the seeds of commercial relationship between Antrix and Devas was a product of fraud that was perpetrated by Devas, every part of the plant that grew out of those seeds, such as the agreement, the disputes, the arbitrable awards, etc., are all infected with the poison of fraud. While addressing a case wherein a Catholic priest's speech created public outcry and the offending speech prima facie attracted various sections of the IPC, the court, in its own words, said that the Catholic priest outraged the religious beliefs and observed Bhuma Devi is considered as a goddess by all believing Hindus. I use the expression believing because even materialists, rationalists and non-believers can also be counted as Hindus. I may add, tongue-in-cheek, that even the great iconoclast and rationalist Perrier did not cease to be a Hindu. Bharat Mata evokes a deeply emotional veneration in a very large number of Hindus. She is often portrayed carrying the national flag and riding a lion. She is to many Hindus a goddess in her own right. Further, the court has also expressed that to uphold the sanctity of the constitution and maintain public order, the strong arm of the law will have to come down heavily on those who seek to disrupt communal peace and amity. In a case that was alleging dowry death, Justice Rajneesh Oswal clarified the scope and applicability of the Jammu and Kashmir Dowry Restraint Act of 1960. Observing that the trial court has conducted a mini trial at the stage of framing of the charge, the bench expressed that the trial was considering the issue with regard to framing of charge under section 304B of the Ranbir Penal Code, but the trial court got swayed by the definition of dowry as defined under the Act of 1960, forgetting that the legislative intent behind making the amendment more when the definition was elastic even for the purpose of Act of 1960 by the use of the expression in this act unless the context otherwise requires. The petition had been filed by the mother of the deceased against the impugned order of the trial court by which the respondents were discharged of offence under section 304B of the Ranbir Penal Code, and instead charges were framed for offences under section 306 and section 498A read with section 34 of the Ranbir Penal Code. While holding against the service charge charged by a restaurant, quorum of Sapan Kumar Mohanty, President, and Ashok Kumar Ganguly, member, rejected the return of the amount which was charged as service charge along with compensation. The Commission has held that the restaurant committed unfair trade practice and further expressed that the restaurant must have been aware of the guidelines of fair trade practice related to the charging of service charge from the consumers by both hotels and restaurants, which is issued by the Department of Consumer Affairs, Government of India, which stipulates that the service charge on the hotel or the restaurant bill is totally voluntary and not mandatory. The Reserve Bank of India has issued Registration of Factors Reserve Bank Regulations of 2022 relating to the manner of granting of certificate of registration to the companies which propose to do factoring business. The regulations provide that the company seeking registration as NBFC factor shall have a minimum net owned fund or NOF of rupees 5 crores or as specified by the Reserve Bank from time to time. The central government has notified the Securities Transaction Tax First Amendment Rules of 2022 to amend the Securities Transaction Tax Rules of 2004. The amendment introduces provisions for collection and payment of securities transaction tax in case of insurance company. Central government notifies Micro, Small and Medium Term Enterprise Amendment Rules of 2022, which introduces criteria based on which sums may be released by the government. The criteria is A. The beneficiary of the fund shall be a micro or a small or a medium term enterprise and shall file the memorandum. B. The fund shall be mandatorily utilized for the project or scheme or activity for which it is approved by the Governing Council. C. The fund shall be dispersed as per the guidelines notified for that particular project or scheme or activity. And lastly, beneficiary of this fund cannot claim benefits from any other scheme or program of the central government or any state government or union territory administration for that project or scheme or activity. Now coming to a few new features, a new topic overview of arbitration and IBC has been introduced in the curated topics on SCC online. Do check it out. The question for this week's SCC online quiz was, which Supreme Court judgment recognizes SCC's right to club and segregate paras in Supreme Court judgment? The answer for this question is EBC versus Devi 2008, Volume 1, SCC, page number 1. The winners for this quiz are Rahul and Akash Kumar Baglekar. Thank you for watching and stay tuned next week for more episodes of Weekly Request.